Good evening, one and all. I am happy to speak to you today on Puttaswamy Judgement. What is this Justice Puttaswamy Judgement? What is happier aspects of it? We will know it. But at the same time, I am totally unhappy because post Puttaswamy decision, the legislation apathy that is being shown is something not acceptable, as citizens' rights are denied day in and day out. The legislative apathy should be curbed and they should legislate suitable law as recommended by the highest court of the land. So that's what we are going to discuss today. First of all, privacy of an individual, whether it is a fundamental right or only a right, it's always a matter of concern. In earlier times, in the earlier decisions, the Honorable Supreme Court has called it as a right, not a totally fundamental right. But as things changed, the circumstances changed, technology changed, the communications become speedier, and the entire ecosystem of communication and information communication technologies impact has changed the whole scenario as far as privacy aspects and protection of it of an individual is concerned. As you know, today, we are in a digital society. More and more entities are using data pertaining to an individual's life for illegitimate purposes. There is no stopping, there is no stoppage, there is no halt, there is no law that can curb it. So it's a matter of concern. As you know, more and more entities are using data pertaining to individuals' life for illegitimate purposes, and they are making huge money out of personal informations, and also they are cheating those individuals by committing cyber crimes. Rampant deployment of digital technology tools by the government, other social sector persons or other agencies who are giving services on digital mode. We can call them as fiduciary, digital fiduciaries and processors. On some pretext or other, they gather this personal data. This personal data, they gather this personal data, they commercially exploit it for profit without the knowledge of the subject. Forget about exploiting for profit. They even enable fraudulent activities on the individual, which needs to be put an end to through an enactment and a powerful enforcement. Otherwise, citizens' privacy is lost. Sir, is privacy such an important thing? Yes, from time immemorial, privacy has been of a primary concern. But in the earlier days, the communication system was not so rampant, so speedier, and therefore the damage that could occur were very, very less. Now today, due to developments in the information communication technology, and people started using digital mode for every activity of theirs, the chances of abusing has become huge. It's very, very tough to preserve one's privacy unless a law is made to meet that challenge. But is it made in India, or are we prepared for it? That's the question we need to answer today. Sir, what is that big challenge in the cyber world? You know very well. It has become a global common. It's open for participation by everybody, and more criminals are there now exploiting it. Entire population can use it, abuse it. We have been a very large outsourcing destination in digital data processing. It also provides economic efficiency without spending much money or effort or time. I can broadcast anything across the world. I can communicate across the world, or I can hack information of anyone, personal information, because there is no legal barrier for such an event. This is where victims are becoming helpless. Secondly, the cyber technology has no respect for national boundaries. Even if there is national laws, that itself is very difficult to implement. But in the absence of such a law, how much more difficult it is, you can imagine. And there is anonymous or pseudonymous, that adds it. So we have cyber crime day in and out. Cyber terrorism and cyber war are become an order of the day. How to face this challenge? It's also a challenge to the legislation as well as enforcement agencies. But as on today, whatever law we are having, they are totally insufficient, as my further part of the talk speaks. Today, I will concentrate more on the decision of the Supreme Court and whether we are in the process of implementing it or we have lost the track. Let's look into that. As you are aware, we have no specific law for personal data protection. During the Aadhaar project, when they started collecting personal identity of all the citizens, there was a huge noise made, because if the data is stolen, if the data is abused, who is going to protect such individuals? And rightly so. It is unfortunate that Aadhaar project has been started without proper legal backing. There should have been a law in place with suitable protections, and then Aadhaar project should have been heralded. I do not know the hurry at which they went about it without making a law is unexplainable. Rightly so, the petitioner, Justice K.S. Puttaswamy, retired, he is a petitioner, kindly note. He filed a petition in the Supreme Court of India challenging the Constitution in 2012. Justice K.S. Puttaswamy, retired, he is the petitioner. He filed a petition in the Supreme Court of India challenging the constitutionality of Aadhaar project on the ground that it violates the right to privacy of an individual. So that's the crux of the issue in that decision that was made. On 24th August 2017, kindly note the date. It is 2017, the decision has come. In Justice K.S. Puttaswamy versus Union of India, the 9-judge bench affirms Constitution of India guarantees each individual a fundamental right to privacy. It says, yes, right to privacy is a part of right to life under Article 21. The decision was also anonymous, kindly note, and 6 judges gave separate concurring decisions. You can see the emphasis by the judiciary. Some of the important observations will help us to know the importance of privacy in an individual's life. So, and why it should be treated as a fundamental right. We will look into the observations of the judges. To start with, we have Honorable Justice Chandrachud J, who is presently the Chief Justice of India. You know very well. He analyzes the earlier decisions of the Supreme Court in the case of MP Sharma versus Satish Chandra, as well as further judgments in the Karan Singh and all that, where in MP Sharma they said it is not a right, privacy right is not a right. But in the other judgments, they went nearer to calling it as a fundamental right, but they never called it as a fundamental right. So these two contradicting views were removed through this judgment. So in this judgment, a firm view was made. Fundamental rights emanate from basic notions of liberty and dignity. Those are the very words Chandrachud Ji has expressed. Although Article 19 expansively enumerates some facets of liberty, this doesn't denude Article 21 of its wide scope and ambit. Privacy is a concomitant of an individual's right to exercise, like other rights in Part 3, that is fundamental rights. Privacy too cannot be an absolute right. Yes, it says it cannot be absolute right. There may be reasonable restrictions. Yes, but privacy is a fundamental right. The right to privacy imposes on the state a duty to protect. Kindly note this word. So state has a duty to protect the privacy of an individual. From 2017 till date, we are lacking a legislation to do so, corresponding to the liability that is to be incurred by the state for intruding the right to life and personal liberty, which is become a mirage in the Indian legal system. The right to life and liberty are inalienable to human existence. They are not bounties. They are essential aspects. In an age of information technology, every aspect of our lives, the courts must impart meaning to the concept of individuals' liberty, particularly where an overreaching presence of state and non-state entities, kindly note, non-state entities, regulate aspects of social existence which bear upon the freedom of an individual. Every individual, irrespective of social or economic status, is entitled to the intimacy and autonomy which privacy protects. These are the exact words he has used. Another judge, Honorable Justice Chalameshwar J, says, among basic rights conferred on individuals by the Constitution as a shield against excesses by the state, some rights are at the core of human existence, and he calls this as the core of fundamental right. Liberty is the freedom of an individual to do what he pleases, he writes. Like all fundamental rights, privacy too has its limitation. He quotes, there need be some legal, reasonable restrictions. But do we need to have a law first and then think of reasonable restrictions? But where is the law? Law of the land is not yet made, not yet made. Very unfortunate. 2017 to 2022, we do not have a law of the land in hand. This should have been done far earlier when we started the Aadhaar project. That is not being done. Another judge, Honorable Justice Bobde J, says, natural rights protect those moral interests which are inherent to human beings. So privacy rights are inherent to human beings. Kindly note, the innate dignity and autonomy of the individual are two such universally affirmed and safeguarded moral values. Privacy is an inalienable as the right to perform any constitutionally permissible act and constitutes the springboard for the exercise of the freedoms guaranteed by Part 3 and can thus be located in Part 3 as a whole. This is the anonymous judgment by the honorable highest court of this land. And even till date, we do not have a proper law in place. Sir, then whether any attempt was made to make a law, privacy law, we will look into some historical aspects. When the Aadhaar trial was going on, Puttaswamy verdict about to come, at that time, government submitted to the highest court that they have formed B.N. Sri Krishna Commission report and they will act upon it. Accordingly, Sri Krishna Commission gave its report in 2018. They placed a privacy bill, PDP Bill 2019, where principal, that is the right holder, the citizen who has a right for his data, has a control over the persons, fiduciary, who collect the data from him. That was a wonderful piece of legislation. I do not know. It did not take the required route. Probably commercial interests played their role, I presume. Because there was also a JPC, it was referred to JPC. JPC also gave its recommendations with amendments. Later on, it was placed in the parliament also after the JPC. It was about to be clear. All of a sudden, government withdrew the tabled legislation, which is unfortunate, very unfortunate. They assured that soon they will bring another law, suitable law. That date we are still awaiting. Very unfortunate. In the meanwhile, I told you some commercial interest may be there. There was another committee headed by Chris Gopalakrishna to look into the non-personal data and how it can be exploited to generate good revenue for the economy, to the fiduciary and to the government. Fine. Data is said to be the new oil, let them do. But whether it can impact the privacy rights of an individual, that is the thing. Now, as on today, privacy rights have no relief at all. Privacy rights are violated right, left and center, and there is no relief. People may argue, sir, in the Information Technology Act, you have Section 43A. You know the fate of Section 43A better than me. There, none of the adjudicating officers from the Ministry of Electronics have taken a lead to decide the issues. They are showing no interest to adjudicate the cases, but no government is ready to take action so that the aspirations of the victims to get damages or protection are met. They are not really interested, let me tell you, in protecting the individual's privacy. That is the situation we have landed ourselves. So 43A is a useless tool. Then what is the way out? We require an exclusive authority, Data Privacy Protection Authority, who can have a sui generis law and implement so that the victims are able to get timely relief. They must get timely relief. Otherwise, no purpose will be served. But no such avenues are being created. There is also now, they are thinking of merging non-personal data and making another common authority. It will go like a mate's performance, and individuals' cries will never be answered if that situation comes, which is really a very, very sad situation for individuals' rights are concerned. Sir, they are tightening the intermediary rules. Certain intermediary guidelines are issued. They are having no impact except a marginal improvisation in the performance of those fiduciaries, but it doesn't speak directly on the rights of the individual being protected. That is what is required. As an individual, my data should get supreme protection. We want law in that direction. As you know, in democracy, personal privacy, right to life, Article 21 has been heralded and held to be the law of the land by the highest court. When the Constitution is given that right, we have not taken up the legislative route to protect that. So privacy is a right respected by every democratic country. You have seen more than 150 countries have brought such law, but in India, we are lacking behind. Even Human Rights 1948 Declaration speaks of such a right. But for us, in India, it has become a dream. Hope the concerned government and legislators, MPs, members of parliament will take up this issue on top priority and come out with a suitable solution very soon. Thank you. May God bless all of you.